Oyez, oyez, oyez. The Honorable Supreme Court for the State of Louisiana is now in session. Order and silence are commanded under penalty of law. God save the state and this honorable court. Please be seated.
Good morning. The first matter on the docket is in re Judge Tiffany Foxworth-Roberts. Would counsel please state their appearance for the record and we'll proceed.
Steve Irving for Judge Foxworth-Roberts.
Marty Maley for Judge Foxworth-Roberts.
Good morning, Michelle Bailey on behalf of the Judiciary Commission.
Okay, thank you. Let us proceed.
Good morning, Mr. Chief Justice and Associate Justices again. May it please the Court, I am Michelle Beatty on behalf of the Commission. Here on the Commission's recommendation that Judge Foxworth-Roberts be removed from office and that she be ordered to reimburse the Commission costs incurred in the investigation and litigation of this matter. I want to start by pointing out that both the hearing officer, Judge Zeno, and the Commission found that the OSC proved every aspect of this case with clear and convincing evidence. It is clear from this record that Judge Foxworth-Roberts' conduct, both in her campaigns for office, regarding an alleged burglary of her car, and in her dealings with the Office of Special Counsel, violated Canons 1, 2A, 7A9, 7B1, 7B2, and Article 5, Section 25C of the Constitution. Judge Foxworth-Roberts engaged in a pattern of dishonesty, obfuscation in her campaigns for office, in the investigation of the alleged burglary of her vehicle, in her response to the OSC's inquiries, during the investigation of these issues, during the hearing before Judge Zeno, and in her appearance before the Commission. It is this pervasive pattern of fundamental dishonesty that brings us unhappily here today. Removal is not a recommendation that the OSC or the Commission makes lightly, but in this case, it is completely appropriate. It is based on review and application of this Court's pronouncements in both the Chason matter and the Whitaker case. In Whitaker, this Court said the most severe discipline should be reserved for judges who abuse their position for their own benefit.
Where was that philosophy a couple of months ago when we had a judge commit gross acts of incompetence on the bench in court?
I'm sorry, Justice, I'm not sure to what you're referring.
Okay, let me ask you another question then, to be certain. Is any of the misconduct alleged in this case in court? Most, as I appreciate it, it's out-of-court conduct during the campaign and so forth.
Well, it is.
But we don't have a complaint in front of us concerning an incompetent action on the bench in open court, correct?
We do not, Your Honor.
Okay,
but this
thank
is all conduct that occurred both in her capacity as a judicial candidate and as a judge. It continued after she was elected.
But not in
to
the
bench.
courtroom.
But not in the courtroom.
Ms. Beatty, let me ask you that. You say that there was misleading testimony to the OSC hearing officer commission. Highlight that for me, because there's a lot of back and forth about the confusion of what may or may not have happened during the campaign. Hit strongly on what you think was misleading testimony under oath before you and the hearing officer.
Okay. I'm going to start, if I could just talk about this pattern of misleading and lies that were told. Because one of the Chason factors is whether this conduct was isolated. I want to emphasize that it was not isolated. She engaged in a pervasive pattern of dishonesty that began before she even took office. It actually began in pursuit of the office, starting with her military service. There were false and misleading statements concerning that service. She portrayed herself in campaign ads as a combat veteran of Desert Storm and the wars in Iraq and Afghanistan. She did that in several campaign ads. in the Central City News that contained a photo of her in Army uniform stating that she was, and I'm quoting, a proud U.S. Army captain and veteran
Ms.
of
Beatty,
Desert Storm.
I've read the briefs, and I'm going to let you get back to your argument, but I'm really interested in highlighting what was done in front of the hearing officer and in front of the commission. There's a lot of he said, she said, back and forth about the campaign. I'd like to know, once this was brought and kind of singled out and brought to light, you're saying she doubled down on it. Give me some examples of that.
Okay, first, in her sworn statement in April of 2023, she was asked twice whether she made the rank of captain in the Army, and she said yes, when that is absolutely, and it is documented to be untrue. She was twice non-selected for that rank. She didn't receive that promotion, but she said affirmatively, yes, that she made captain. In addition to these ads that she had put out stating that she was a captain. And there was an article in the Central City News, March of 2020, in which it said she served in Desert Storm. She served in the wars in Iraq and Afghanistan. So there was clearly this effort to portray herself as a combat veteran, and also that she had made the rank of captain. There was, in her initial response to our inquiry, we sent her an inquiry which contained the complaint, which the complaint obviously stated that she had made or alleged that she had made a fraudulent insurance claim to USAA. In her initial response to us, she unequivocally stated that she did not file a complaint at all, or a claim at all with her insurance company. It was only when we sent her a subsequent supplemental inquiry that she acknowledged that she had filed a claim with USAA. When we dug deeper, and this took, place over months, it turned out that she had not filed one claim, but two claims to USAA. The second claim for a $19,000 ring that she never reported stolen to the police. So that was also another.
Counsel,
Yes.
on the insurance claim, in reading the record, there was some issue as to whether there was a misunderstanding as to whether it was a homeowner's claim or a vehicle claim. So what was the particular question that was posed while she was under oath? Was it whether you filed a claim or whether you filed a homeowner's or whether you filed an auto claim?
Just to be clear, this was our initial inquiry, our written inquiry to her that I'm referencing right now, which is
Okay.
not under oath.
Okay.
We send a respondent judge a copy of the complaint along with specific inquiries, and the question was whether you had filed an insurance claim.
Okay.
Didn't specify auto, homeowners, and insurance claim. And keep in mind that the complaint itself specifically referenced USAA. Instead of acknowledging a claim with USAA, she said, I didn't file any insurance claim at all, and provided us documentation from State Farm to show us that she didn't file a State Farm claim. Well, come to find out, she did file
State Farm was her auto.
her auto insurance.
Okay.
Now, she didn't put that qualifier in her response. She just said, I didn't file any claim at all. And as I said, we did later find out that she did file a claim with her homeowner's insurance, USAA, which we only found out by sending that supplemental inquiry.
Okay, and again, back to Justice Cole, what else under oath or?
Well, there is the testimony about being a captain in the Army. There is testimony about not knowing. She claimed to not know about the second claim for the $19,000 ring. However, the insurance records belie that. They show that she contacted USAA at least 3 times to make that claim. She attempted to tell us that it was USAA's idea to put it on the second claim, which absolutely was not true. The records show that that was not true. She also claimed that she never saw the ads that were run in the Central City News, which is just not credible testimony. She paid over $7,000 for 9 ads that ran over several months, both in her initial campaign and then the subsequent campaign for the full term.
Was there testimony from the person who placed the ads. I think it was former Representative Jenkins. Did he testify as to whether she saw the ads? I thought I read something where he testified that she did not. Am I correct?
He did, he
Okay.
did. However, if you just look at the circumstances, this is an individual who paid $7,500 for ads over the course of months, and she claims that she never saw them, or it doesn't make any sense that someone would pay all of this money to run these ads and not even verify that the ads were run, not even verify that the information that she wanted to put before the voters was out there.
I don't know if someone involved in a campaign necessarily stops to look at all those things, quite frankly. I don't, having been in campaigns myself on occasion, sometimes you have people that are hired to do that kind of work for you. Let me ask just kind of a globally question. It seems like in her, and Justice Cole was kind of focusing on this, if you look at what happened, there may or may not be explanations, but it seems like she buried herself in not being forthcoming and changing her story and not addressing the questions posed to her in a proper manner. Would that be a fair statement?
That would be more than fair, yes. The hearing officer found, and I just want to point this out as well, so there were general facts found, but there were additional findings solely on the issue of Judge Foxworth-Roberts' credibility. And what he found and what the commission adopted is that Judge Foxworth-Roberts had little, if any, credibility, especially given her position as a judge, because she made so many significant false and misleading statements to the voting public, the Baton Rouge Police Department, her homeowner's insurance company, and the commission, and the OSC.
Yeah, and you have, as Justice Guidry said, former Representative Jenkins saying that, kind of accepting some of the responsibility for the ads. And apparently neither USAA or, which paid the claims, and the police department saying we found no evidence of fraud. But then she tells some story that this occurred at her home, although this incident ended up happening at another location.
That's
And then
correct.
some allegations that, well, she drove her vehicle home to get coverage by her homeowner's insurance, when in truth and in fact her auto insurance was going to cover the claims.
Well,
Is that all mixed into this in some?
It is,
odd?
and that, this was a case that,
I mean, nobody, is there definite proof that she engaged in fraud?
I don't have any evidence of that. And this is not what the commission charged her with. There are lots of questions around the stories that she told, and
Don't deny that.
what I can tell you is that what we have proven is that she was untruthful in so many instances. Now, what conclusion you draw from that in the context of a criminal law arena, that's not our purview. But what I can tell you is that she violated the code of
I
judicial
read in the brief
conduct.
that she, from opposing counsel, that no, the police didn't charge you with fraud, and denied that this generated a fraud investigation even, and that USAA is what she's being charged with, all of the false statements
Yes.
that were generated within the investigation.
Yes.
And if she would have just told everybody precisely what happened rather than obfuscating, as you indicated, would we
Yes.
be here today?
We likely wouldn't be,
Well, Ms.
because
Beatty-
I believe that much of what we discovered was only discovered because of the efforts she took to keep us from discovering
Understand.
what happened.
That's really my question. So, let's separate the two parts of your case. You have a part of your case that remains disputed, where we have to assume that the commission was correct in discrediting the testimony of Woody Jenkins and all these other things that y'all did to get to the kind of campaign pre-investigation components. Those are in dispute. And then you have, I think, some things that are not in dispute. It sounds like she reiterated the statement she was the captain, which is objectively not true during the investigation. All right, that's hard to explain that. It looks like she denied having the insurance claim, even though you put in the charging document USAA, you mentioned the one you were looking for. That seems like that's not in dispute, and that's a serious issue. Is the discipline that you have recommended, if you assume that the pre-stuff that's kind of dispute, the campaign-related stuff, were not, y'all didn't find those charged, and you were just charging her for misleading your investigation, would you still be asking for the same penalty?
That's a large hypothetical. I think potentially yes, because
And
if you
why?
look at In re King, the language from In re King, which was a removal case, the court specifically found that the lies that he told to the Office of Special Counsel and in the context of the investigation were even more reprehensible than the underlying conduct. You corrupt the process when you're not truthful with an entity charged with making sure that judges are meeting the ethical standards, the high ethical standards that we expect judges to meet. You corrupt the process, and so
But,
potentially.
King was ordering his staff to go sell tickets to campaign functions.
Right.
And apparently, he ordered them into the courtroom, and someone turned on a recording device. And when he was asked if this occurred, he absolutely said not. But both of those actions, the lie and the corruption of the process, there's obviously puffery in campaigns. But when she went to y'all and was questioned, she said, yeah, I'm a captain.
Right. This is
And
beyond.
now she says, well, her argument is, well, she wasn't focused on that question. She was anticipating the next question. Well, that's a little bit hard to believe. Is she, I tell new attorneys this all the time, or people that apply to take the bar, be incredibly truthful when you apply, because if you are not, someone's going to find out, I assure you. And I believe as a body, the court is more willing to accept human frailties, that you made a mistake and you learned from it, than dishonesty. But it seems like every time she had the opportunity to tell the truth, she said something different that's demonstratively false.
That is true. The misleading, the efforts to mislead and the lies are so layered. It's so wide and broad that it's hard to get your arms around.
Well, the comment by the hearing officer is pretty devastating in his written,
Exactly.
in his writings.
And I just
And
want
you read it, you shared that with us a moment ago.
Right. And I just want to emphasize that these were not, isolated instances of an error in judgment. What we have, again, in this case, is a pattern of misleading responses and lack of cooperation, responding yes to a question as to whether she made the rank of captain when she didn't. It's not a lapse in judgment. That's an affirmative untruth. Submitting a response saying unequivocally that you didn't submit an insurance claim when you actually submitted an insurance claim for over $38,000 worth of property is not a lapse in judgment or an error. That's an affirmative untruth. Telling a police officer that a burglary occurred in your driveway and then, there's body camera footage that objectively shows that that is not true. You definitely indicated and misled this officer to believe that it took place in your driveway. So the decision to pay this money for these campaigns, and I appreciate your point, Chief Justice, as far as, someone's busy in a campaign, they may not look at every ad that they pay for. It does not absolve her of the responsibility of making sure that the information was correct. And what we do have affirmative proof of is that this information, that she was a captain, that she was a veteran of Desert Storm, Iraq, and Afghanistan, came from her, because there is a sign that she produced that references herself as a U.S. Army captain, showing her in fatigues and a rifle in her arm and a combat helmet. So this information came from her. Whether you believe
Mr. Jenkins
Mr.
said that
Jenkins or not is really irrelevant, because she is ultimately responsible. And what we have documented is her own untruths about her service.
Ms. Beatty, I want to drill down on that for just a second. Mr. Jenkins took responsibility for the ad in the Central City News completely. But you're saying, I believe from the record, there was a campaign sign or push card or something that was not produced as part of that still said U.S. Army Captain?
That is correct.
Okay. And that was paid for by the campaign?
Yes, that was produced by her campaign.
And she refused to allow her military records to be released.
That's true,
That
yes.
would have proven that she was not a captain, that she'd actually been denied captain status on 2 occasions,
That is true. When
which
we
resulted in her being separated from the military. I didn't realize this was a rule, but apparently if you apply for a higher position and are not accepted into it twice, you're required to resign.
That's correct. When we initially attempted to get her military service records, we sent a request directly to her and her counsel at the time. We didn't get a response. We issued a subpoena to her. She initially responded on her own, saying she didn't have the records. So in August of 2023, we asked her to sign an authorization that would allow us to get the records directly from the Army. We got no response. We asked again in October, got no response. We asked again in November. Finally, in November, she admitted that she was 16 years old during Desert Storm, but she failed to sign that authorization form. It wasn't until April of '24 that we received documentation from the Army that confirmed that she never obtained the rank of captain, and it became painfully clear at that time why she didn't want us to have those records.
Did she authorize it, or you all had to go through a different process?
We had to go through a different process, which we don't even know if we got all of the records, because using this process, we weren't guaranteed to get all of the records because we didn't have her authorization.
Is one of the issues that you all have is her failure to cooperate and or at least being slow in cooperating with you all?
Yes, it is.
Thank you.
Yes. So getting back to the Chason factors and just sort of how we're analyzing this and how we end up at removal recommendation, to Justice McCallum's point, yes, this conduct occurred outside of the courtroom, but it was in her capacity both as a judicial candidate and a judge. You know, they make an issue in their brief to say that this was all prejudicial conduct. No, it began as prejudicial conduct, but it
And
continued.
that's not to say it excuses the conduct. But,
Absolutely not.
But you would agree we want some proportionality in punishment, right? And yet, earlier this year, you kind of set the stage for what punishment we're going to have. We had what I would call, from one judge, amazingly, 3 distinct, separate, discrete instances of gross incompetence on the bench. What you're accusing this judge of doing tangentially affects the lives of all the people, obviously. But the other judge earlier this year, that you couldn't recall a while ago, directly impacted the lives of the people in the courtroom whose lives, liberty, hung in the balance.
Well, Your Honor, I would just point out.
That judge, coming out of the same judicial district, I might add, got an 8-month paid vacation.
Your Honor, I just want...
How do we reconcile those two things? Did y'all just wake up or something, or what?
I want to say two things on that. One, we try to follow this court's precedent. We try to do that in every case. And so while we may argue a case, I'll just, say that you all, the 7 of you, decide what that precedent's going to be going forward. So it isn't...
But you make recommendations.
We do.
You have brought a recommendation
We do.
to the court in this case. You brought a recommendation to the court in the case I've referenced previously earlier this year.
That is
That's
correct.
on y'all.
Absolutely. And as I said, we try to follow this court's precedent and make a recommendation. A recommendation is just that. It is a recommendation which you are free to follow or not. You can go above it, you can go below it. But we do our best to make a good effort to, and remember that the disciplinary process is to focus on protecting the public. It is more about protecting the public than disciplining the judge, yes.
Oh, in that particular case that Justice McCallum referenced, that was, you all had consent, you all had agreed between you and the judge as to what the recommendation was to be. Is that correct? Is that a difference here?
If you're referencing Judge Foray, which I think that's,
No,
is that what we're
he's not
talking about?
representing
No,
Judge
Judge
Okay.
Foray didn't convict somebody of a crime that does not exist. Judge Foray didn't bring a jury back into a courtroom to change their verdict, among other things. What Judge Foray did was reprehensible, but that's not the case I'm referring to.
I understand. I see now what you're talking about.
Yeah, but in that particular case that he's referencing, in that case, it came to us in terms of a consent. You all had agreed, and there evidently had been cooperation between you all and the judge.
Which makes my point. You
And
agreed
there's
to it.
also, I mean, every case is different, right? Every case is going to have a different set of facts. Every case is going to have a different level of cooperation from the respondent judge.
And I guess that's,
Every-
So you can be incompetent and cooperate and everything's forgiven.
I don't think everything was forgiven in that case.
Well, that's a difference of opinion.
but one difference in that case and this case is the cooperation, the consent, and I think a part of what is here is the question of cooperation and the underlying actions are really not why you are moving the baseline. I assume it's based upon, you're saying, based on King in particular and other matters, it is your position that it is the dishonesty,
Yes.
alleged dishonesty, that serves as the baseline for removal versus the competency that was referenced with regard to the other case. Am I following?
Yes, there's the issue of the dishonesty, which reflects so poorly on the character of the respondent. And remember that a judge is sitting in judgment of other people's credibility every single day. That's like a primary function of a sitting judge. And you have someone whose credibility is so severely compromised, who is tasked with sitting in judgment of others on a daily basis. I think it's a big ask to allow her to continue in that role. There is the lack of cooperation. There is the lack of acknowledgement of any wrongdoing. There are distinctions between this case and others because of that lack of acknowledgement of any wrongdoing. No effort
And I don't
to correct.
excuse any of this behavior. I just wish you would have given us the hammer 6 months ago to use here.
I understand.
But you
Justice.
missed that opportunity.
Well, right now, what we have before us is a set of facts which I believe meet the requirement for this court to impose this most severe sanction. Because again, we're looking at a judge who has demonstrated such a profound lack of care for the truth, not only in her dealings with the public in order to get elected, but in her dealings with the Office of Special Counsel and the Commission in its investigation of this matter. It is offensive. I think it should be offensive to this court because it corrupts the process so severely.
You want to reserve the rest of your time?
I do, thank you.
I'm sorry, I didn't mean to interrupt you.
No problem, thank you.
If I save you a second, you get back up.
Good morning, Chief Justice Weimer and the other members of the court. Steve Irving, and I'm here to present the argument for Judge Foxworth-Roberts. And I swear I wrote this before the questions. When I mentor young lawyers, one of whom was Tiffany Foxworth-Roberts, I always give them two basic survival rules. The first basic survival rule is to win a case, you must first not lose it. And the second one is details matter. I was pleased that Justice Cole raised the question about details because the details are important in this case. This is a case with a lot of summary conclusions, and the details show this is not a removal case. Now, you know, in most places in the country, people can be proud of their military service. The question here is, when a candidate runs for judge in Louisiana, can they speak about their military service without being second-guessed about the way they said it? First, I want to talk about some details before I talk about the details of the military service.
Well, Mr. Irving,
Yes,
I don't think we're questioning her military service in any way, shape, or form, nor as the Judiciary Commission. I think they're questioning the fact that she said one thing, repeated it under oath when asked about it, refused to cooperate in allowing her military service to be viewed, to corroborate what she said in a campaign, and then it proved to be absolutely not true.
Well, I'll address that right now.
Okay. That's why we're here.
The statement under oath that you're talking about began with counsel for the Judiciary Commission telling her the only thing they were investigating was the car burglary. Now, she was asked two compound questions. I know everybody's seen that 1,000 times. The compound question, the first compound question was whether she was a commissioned officer and then rose to the rank of major. And the second compound question was whether she was in the Army, and then raised a question about it. The second one, she responded, the Army, yes. The first one, she responded, yes, yes. And you don't know what she's responding to, whether she's responding to being a commissioned officer or responding to the rank of captain. Now,
So when communicating to your client, you do not use compound questions?
when I communicate with my client, I absolutely will warn the client about compound questions. I will present the client with some instances of compound questions, and I will give them a very hard time because I will become the other side, and I will try to give them the experience of what they may get from my opposing counsel. That's part of, to win a case, you must first not lose it. But this began with Judge Foxworth-Roberts being told that the issue was the burglary.
Mr. Irving,
Yes, sir.
I want to follow up on that, because to me, this is an important point. I can understand the confusion that comes from a campaign. And she has folks that are fine, upstanding citizens that are saying, it's my fault, I'm responsible. I think that it's reasonable that we could accept that. But what that doesn't answer is what we just talked about. We're not talking about a person off the street. This is a lawyer and a judge. And they're being asked a question twice. You were in the Army and you were a captain. I would think any rational person would correct them, knowing that that's untrue, and say, oh yeah, I was in the Army, I was only a lieutenant. Something to be proud of, not something to be ashamed of. Why twice Did she not correct that misstatement under oath? And in fact, answering yes, comma, yes to the compound question seems to affirmatively affirm it.
The only thing I can tell you to that is that it was a compound question, and she was responding to the issue of being in the Army and responding to the question of being a commissioned officer and not addressing the rank.
All right, let me ask this one, because I think this is another important misstatement to the commission. And you know, there was a saying back about Nixon, it's not the cover-up, it's not the crime, it's the cover-up.
Yes, sir.
And that's what this feels like. I mean, I feel like some of the campaign activity could be explained, but it's hard to explain some of the answers to the questions. And so, after you receive a complaint that says specifically in it that you are accused of insurance fraud, the insurance company was USAA. That was the complaint that was provided to her in writing, references USAA. And then you get a question that says, did you make an insurance claim related to this car burglary? And the answer is, no, I did not. Oh, and here's some proof about State Farm. How in any rational person's mind did you not know that the question was about USAA when the complaint you were provided in writing expressly references USAA?
She was speaking about State Farm and provided the answer as to State Farm, but the fact of the matter is, from the get-go on this, the USAA company has acknowledged that everything in her car, all the movable stuff in her car, was insured anywhere in the world. She did not need to move the car anywhere to make a claim on the USAA policy.
Right, but nevertheless, she did move the car and then didn't share that information. You know, it again, we have hearing officers to evaluate veracity. And in no uncertain terms, the hearing officer, who is immensely competent, indicated that her, and he got to witness her testimony, was in no uncertain terms that she cannot be believed in anything big or small, essentially. I mean, how can we overlook that?
I think the answer to that question...
And we apply the manifest error rule, by the way, correct?
Well, in the terms of the penalty you impose, I think that's your prerogative. Now, she testified, but I think you have to understand the entire situation in order to understand what's going on. And the fact of the matter is...
I'm trying. Help me understand it then.
Most of what she said about her military service is actually correct. The Desert Storm, yes, she joined the Army after Desert Storm, but if you look at what happened, she was in the demobilization, and she treated the wounded soldiers from Desert Storm. And you know, the war's not over for the wounded soldiers and the military people who take care of them.
I don't think anybody denies that. It's just...
I think there was...
the judge's findings were the judge's findings, and how do we... And there's plenty of evidence that they point to that collaborates what he said, the hearing officer did.
The only statement in this whole thing about military service that can really be questioned is the statement about being a captain. And I want to directly address that, because all of the package with Woody Jenkins was the advertising in his paper, and also some things at Central High School football games where he's is the announcer. So We're not exactly sure where that picture that's got the little language written on a caption came from, but it's probably from that. Everything that was published in this campaign that has her in fatigues came from Woody Jenkins. Woody Jenkins straight up said that she never told him she was a captain. Woody Jenkins didn't know where he got the information that she was a captain until right before the hearing. Woody Jenkins goes and looks to her social media page, which is where all of those pictures came from. And on the social media page, he notices that the picture with her with an M16 rifle, she's got a captain's helmet on.
Mr. Irving,
Yes, sir.
I understand he took full responsibility for the ads.
Yes.
Did he also take responsibility for the campaign sign that had U.S. Army Captain printed on it?
I don't think he was asked that question, but that campaign sign was part of the package with Woody Jenkins.
Is that in the record?
I'm not sure how clearly it's in the record, but everything where she's in fatigues is stuff that came from Woody Jenkins. It all was harvested from her social media page. The only written document, the only written campaign document that is in this record is the part of the Woody Jenkins ad that's in yellow, because that was literally her campaign push card. That was her campaign literature.
Counsel, over here.
And that is in the record.
Counsel,
Yes, sir.
so let's put the Woody Jenkins piece aside in terms of what he represented. But was she ultimately asked specifically whether she was a captain? And because what I'm getting from opposing counsel is that they're not so much focusing on what Mr. Jenkins said with regard to the campaign ads, but they're focusing on her response under oath or in submission as to that particular question, were you a captain? So did she make that representation under oath or in any submission?
The words, "I was a captain," never came out of her mouth. Now, what happened was there were two compound questions, both of which asked another thing and raised the captain issue, to which she responded. The first time she responded, yes, yes, and the second time she responded, Army, yes.
Well, let's back up. So you're saying they ask her two questions, compound question, and she says yes, yes. And so if one of those questions is, were you a captain, one of those yeses was to whether you were a captain. Am I following that correctly? Compound question, two questions, two answers. One of the questions, are you a captain, and an answer would have been yes, because it was yes to both questions, including the question of whether you were a captain. Is that what the record reflects?
From a grammatical basis, you might analyze it that way. From a compound question, as a lawyer, when you ask a compound question, you don't know what the answer that you get means.
I guess I'm a little confused, because if I'm a judge and I'm being asked about specific instances and specific facts, I would, and perhaps I'm a little different from the judges on trial, obviously, at this time, because I would bend over backwards to make sure I give accurate information. Are you suggesting that because of the way the question was asked, she could not give accurate information?
I'm suggesting that because of the way the question was asked, the response that she gave did not fully address the question.
And so going back to what the chief asked, if the judge, the person who's sitting in judgment, looking at the witnesses, hearing the responses, has both the written response, and her demeanor and her response on the stand finds her to not be credible, you don't think that that's sufficient for him to have drawn that conclusion?
The basis for finding her not credible was accumulation of many other things, a lot of which involved the military service issues and the conclusions that were drawn about her military service issues. So I don't think that you can isolate that and say that's the basis for his conclusion about her
I'm not
credibility.
trying to isolate it. I'm trying to consider whether or not, as the chief said, we give deference to the person who actually sat there, reviewed the evidence in person, heard the demeanor of all the witnesses, not just Judge Foxworth, but also Woody Jenkins and anyone else that testified either on her behalf or otherwise, and made a conclusion. And the question is whether they were manifestly wrong. You're suggesting to me that they were manifestly wrong.
I am suggesting that they are manifestly wrong when you look at the total of the details that are discussed and the total of the conclusions that are drawn, that the details do not support the conclusion. Now, I want to point some things out about the campaign, which goes without saying, but I think, first of all, I want to call the court's attention to the fact that there have been no allegations about Judge Foxworth-Roberts doing anything wrong on the bench. She's been a fine judge. There's no hue and cry from Baton Rouge that she should be removed. Nothing. No allegations of misconduct. Now, the campaign in this case occurred under the worst conditions in this country in a century. This is at the beginning of the COVID epidemic. People are dying of COVID. People are getting sick. People are avoiding people. People are not interacting the way people normally do. She's trying to run a campaign. While she's running the campaign, her mother has stage 4 cancer, and every 3 weeks she's having to take her back and forth to MD Anderson Hospital, do her work as a lawyer, campaign for judge, and literally living out of her car. Now, if you want to walk a mile in her shoes before you criticize her, that's the things that you have to take into consideration. Now,
I don't mean to get you off a train of thought, because, you know, what you described is obviously straining, but you've tested my skills of logic, and this is going back to an answer you gave to the chief about the Desert Storm Service. Is it your logical proposition that if a naval or Army surgeon today performs surgery on a Korean War veteran, that he served in the Korean War?
no, sir, I'm not, and I'm not
Okay,
advocating
well,
that.
I want to make sure I didn't misunderstand that.
But in this case, the troops were being demobilized.
I understand what you said. I just want to make sure you didn't really mean it.
In fact, the Defense Service Medal for that
I got you.
campaign.
Go back to what you were saying a while ago. I think you'll be more effective there.
Sure. And I had a whole bunch of stuff I was going to say about the facts of her active duty, but the fact of the matter is, she's got a very good argument to say to the public that she served in Desert Storm because of what she did. And she served then as an enlisted person and later as a nurse during a period of years when there were repeated national crises.
We appreciate her service. There's no deprecation of that.
It again goes back to what we were talking about earlier. It seems to be the seeming refusal to tell the truth is what the hearing officer said, essentially, and would rather not address the question asked and come up with some long explanation that had no relevance to what the question was, giving the impression that she's not interested in sharing the truth. I mean, that's, Justice Cole, I think, said, it's the cover-up is worse than the crime.
Well, but what's the crime? She's got insurance coverage anywhere in the world. She's at the point in time that statement is made, she's told what's being investigated is the insurance claim. She knows moving the car had nothing to do with it. Nothing to do with having a valid claim.
Then why tell the police officer that the car was at a different location if you didn't think it mattered?
What she said was it was parked just like that, and she pointed over to where her car was parked, and it was parked lined up in the driveway. It just wasn't that driveway. It was 3 miles away. This is in South Sherwood, and the place at the...
But she didn't share any of that information.
She didn't share that
It was
information, but she didn't lie to him either.
Well, that's maybe too fine a line for us to accept.
And Mr. Irving, she also didn't correct him. He leaves and he hands her a form that had the incident location as her address. She doesn't get that and say, "Oh, sorry, we've had a misunderstanding here today. The incident location was not this address." Or, and then the other thing is, even after saying there was no insurance claim, when she ultimately does say there's an insurance claim, isn't it that she provided one of the two insurance claims and not the other? And then when they asked her, she said there's only one claim? What I don't understand in this case is that there's like a quadrupling down on things that probably could have been explained and would have made life much easier to have been explained.
I think the answer to that question is there are two insurance claims with USAA, but my recollection is it has the same claim number, but it's on different policies because she had a policy and her husband had a policy.
Okay, so fine. Again, it seems like there's a reasonable explanation. Why not give it instead of saying there's one claim when asked? I agree with you. It shouldn't matter. So why didn't she do it? That's the root of this question.
Where were the inquiries about the insurance claim? Were any of these under oath, or is this because what she's talking to the police back and forth about? Was she asked under oath about insurance claims?
She was asked in submissions to special counsel about it that were provided. I think
She wrote back and said all this stuff, but that's not under oath, right?
I don't believe that's under oath. I think the ultimate.
What about at the hearing in front of the hearing officer? Was she asked about the insurance claims in front of the hearing officer?
I think she explained the insurance claim in front of the hearing officer, and I don't recall there being anything she said about that was inconsistent with the facts. But I do want to talk about that because there is something that's important about that insurance claim and something that needs to be said. This campaign's at a point in time when the campaign workers are hard to find. And she's got 3 people with her. One of them is a convicted burglar and liar. Now,
Is all that's in the record?
yes, sir.
This is a campaign worker?
This is the campaign worker, and I'm going to connect all this up in appointment because it's important. Guess who's the one who finds out that her car has been burglarized? The burglar.
Well, who hired the burglar?
Judge Foxworth-Roberts hired the burglar, and she didn't know he was a burglar. Now, he's the one who reports it, and Judge Foxworth-Roberts comes back to her car, finds it's been ransacked, and this is all well and good. This guy, that burglar, ultimately becomes, he is probably the anonymous complainant, or at least the information behind the anonymous complainant, because of the details in that. There's nobody else but him that would know. Now,
Did you call him as a witness to question him about that?
the special counsel tried to take his statement, and he was wherever gone.
Mr. Irving, with all respect.
Yes, sir.
I'm going to suggest that you're chasing a rabbit, because here's the issue. Let's assume he is the bad dude. He tried to extort her. He made an anonymous complaint after he tried to extort her. I'll spot you all of that. They're not doing anything they're doing based on his testimony. He may have been the reason we started this, but everything in front of us today is about what she did subsequent to that. So even if it's true that he had something to do with the break-in and he extorted her and he turned her all, and he tried to turn it over to the other candidate, all of that could be true. What does that have to do with what's in front of us?
It has to do with this. When she is reacting to this investigation, she's reacting to it at least partially as an ongoing victim of an extortion plot. Now, this is another situation where you've got to walk a mile in her shoes to realize what's going on. But she was an ongoing victim in an extortion plot.
And that's what's going on at the time of the robbery?
No, ma'am. This is after the burglary of her car. There came
I'm
to the
asking the
appointment.
question because are you suggesting that the quote-unquote extortion is why she lied?
I'm not saying that she lied. I'm saying that
She stretched the truth?
I'm not saying she stretched the truth. I think it's more how she is reacting. Now, where the extortion plot comes along.
And you're suggesting to this court that we would want judges on the bench who will respond to stress, which being a judge, being a lawyer, is an extremely stressful lifestyle that we choose to a profession we choose to be a part of. Are you suggesting that we should forgive that because of the outside circumstances of what is going on in her life?
I'm suggesting that you should understand that. How much you forgive it is your prerogative, but I'm asking understanding in this case.
You want us to forgive? Has she asked for forgiveness? Have you asked for forgiveness up here this morning?
She's given justification and excuse.
I'm sorry?
She's given justification and excuse.
I was headed there because we did straight up in our brief and earlier point out that with regard to the statements in the advertising about being a captain, she has accepted responsibility for that. She did not provide the information and she didn't know about it, but the fact of the matter is she should have checked her advertising. She should have made sure that the advertising was accurate, and she did not. Now,
But has she ever said to the commission or anybody else in a formal setting, I am sorry for this behavior, I'm sorry for the misrepresentations, and I will never do it again?
she has most definitely...
We've heard a lot of explanations this
Sure.
morning, but I haven't heard any remorse.
Well, the answer to your question is she has absolutely no intention of ever doing it again and has made that crystal clear. Now, she's also tried to explain the circumstances so that everybody understands what was going on in her life at the time, which I think is important. Now,
Mr. Irving, you argued it's not a removal case.
I am arguing it's not a removal case. yes.
What is the proper penalty in your mind and why? What's the support for that?
Well, certainly no more than a suspension, and an educational component would be appropriate to recognize that there are things about campaigning that she needs to know and understand. That's the limit of my thinking on that. There obviously
Would she also benefit from teachings that you should not stretch the truth?
I think she would benefit with the kind of mentoring and education that I talked about when I started about focus.
You said you had mentored her on
Yes, sir.
that at some point early in her career. Apparently, like I used to tell my students that fell short occasionally when I taught ethics, maybe I was a bad teacher, maybe you were a bad student. I'm not sure what happened. but you were certainly taught better than this.
I
She
mentor.
needs to be taught again.
Hmm?
She needs another teacher. She needs to be taught. The truth is essential as a judge.
Your Honor, I
You
think.
can answer that.
Okay, I'm going to answer that with what I think is the absolute truth. I think it's focus. The issue, every one of these issues involves focus. And I think that the training that she needs is in focus, learning to focus and understand. She's a very smart lawyer, a very good judge, but under stress, as we pointed out, sometimes she hasn't focused. And that's that. If the court's going to do something in this case, and I don't know what you do for that purpose, but focus.
Thank you very much, Mr. Everett. Rebuttal?
Just a couple of points, and I may bounce around a bit. First of all, on the question that you asked, Justice Cole, about the sign, it was generated by her campaign, the sign that had the caption U.S. Army Captain. She acknowledged that during the hearing
But
in her testimony.
was it generated by Mr. Jenkins?
It was not. Mr. Jenkins was specifically asked about that sign, and he said he had nothing to do with the production of that sign. On the issue of the second insurance claim, there were 2 claims and 2 claim numbers, one on their home and one on a second property. And in the insurance records, you will find where Judge Foxworth-Roberts told the USAA representative that she had stayed in that second property within 60 days of the claim being made. Just want to point that out.
Was she questioned about the insurance claims under oath?
Yes, both in her statement and also in the hearing.
And she had like a sworn statement and then testified in front of the hearing officer?
That's correct.
Okay.
And I want to point out to you as well, you know, we're at a point where they have argued in their brief, and to some extent today, that most or some of what she said was arguably not untrue. And she's relying on testimony from, you know, her former colleague and herself that what she was doing in the lab qualifies her to be a veteran of these foreign conflicts. I want to note for you that in the Central City News article of March 2020, it reads as follows: in the Army, she served in Desert Storm and in the wars in Iraq and Afghanistan. She proved she is the real deal. There was a concerted effort to portray her as a combat veteran, which was simply not true. This is a case that merits removal because you cannot teach a judge to be honest. We shouldn't have to teach a judge to be honest. Thank you.
Thank you. Matter will be submitted. On deck is State of Louisiana versus White.